Hello, and you're very welcome to episode 28 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisis.ie.
Mark, good to see you as always. And last week, you will recall, we had another international outing of sorts as we talked to Dominic Carman, who told us about his own work with the big 6 law firms here in Dublin. Really, really interesting. And then very generously gave us what at times was a front seat account of some of his late father, George Carman QC's best known cases. Mark, I loved this interview.
Yeah, and I mean, it really was literally a front row account because he'd actually sat through a number of his father's most high profile cases, which must be unusual enough. But he said his dad actually liked him to come and watch him in action.
Even gave him some of his best lines.
Yeah.
Do you remember Jeremy Thorpe, the 12 most important votes you've ever got?
Yeah.
Wasn't that him? I think it was Dominic who gave that to him. Oh, it's fantastic. Folks, listen back to it. It really is a great piece of interview. I think you'll really enjoy it. Okay, well, today we are returning to probably the most controversial issue that we have aired on this show to date. That, of course, is the recent academic report which suggested that the presence of Wikipedia can be spotted to a measurable degree in Irish High Court judgments. 2 weeks ago, Dr. Brian Flanagan, Associate Professor of Law in Maynooth, came into studio to defend his findings. Well, today we're throwing the floor open to the other side in this debate, and it is our great pleasure to welcome to the studio Mr. Justice Richard Humphries to set out the reasons why he believes the Maynooth study is flawed, and he does not believe that it stands up in any way. Well, Mark, as you know, unfortunately, due to the fact that I was delayed at a trial earlier, I raced out, I did my level best, but I was late, so I don't take part in the interview. It is you on your Tobler, you on your lonesome doing the interview, and I'm really looking forward to hearing how it went. Yeah, so how was it?
It was great, I hope. Unfortunately, I suppose because I felt I had very much put the case for the prosecution when talking to Brian Flanagan, I hope it doesn't sound too much as if I was sympathising with the judiciary, but I've done my best
I'm sure you weren't.
As even-handed as possible.
Don't you know you were? Well, like our listeners, I'll be tuning in to hear what Mr. Justice Humphries has to say. I think it's fantastic that he came into us to talk to us. It's really, really good. We're really impressed with that and delighted that he did. But first, Mark, we're going to discuss 3 cases which you have identified on the Decisis website. And we start today with a valuation case involving toll booth receipts and whether they had been correctly valued for rateable purposes. This is the case of Eurolink Motorway Operation Limited versus the Commissioner of Valuation. It's a Court of Appeal decision from Mr. Justice Houghton. In this case, the Court of Appeal dismissed the appeal from the High Court on the basis that the toll booth receipts had been correctly valued for the purpose of assessing rates.
Yeah, well, as you know, I do my level best to find the most technical and obscure topics to cover.
This is what you call a car chase.
Exactly. So I do think it's interesting. Basically, as you know, most of the motorways in this country were developed under what they call a public-private partnership arrangement. As a part of that arrangement, a share of the toll booth receipts is paid to a statutory body called Transport Infrastructure Ireland. So basically, the Eurolink motorway operation, which runs some of these toll booths, wanted to claim that when they were paying rates, they shouldn't have to pay rates on the income they receive that they then remit to a statutory body. And so basically, the valuation tribunal determined that they did have to pay rates on those, and they appealed that to the High Court and then onto the Court of Appeal. And at each level, they were told, no, it is correct that they do have to pay rates because the rates are determined at the point of receipt, and whatever arrangement they have with the government is a different matter.
Very good, very good. I think you made a yarn out of that one, Mark. Fair play to you. Okay, well, next to a planning judicial review, which found that a county development plan was not consistent with the national planning framework. This is the case of Protect East Meath Limited versus Meath County Council, a decision of Mr. Justice Richard Humphries, who's the star of today's show. He granted an order quashing the decision by a local authority to adopt a county development plan on the basis that parts of it were not consistent with the national planning framework, specifically in terms of the relevant population projections going forward, I presume.
Yeah. And so basically the national development plan obviously is the plan for the entire country. And under statute, it is a requirement that local development plans or county development plans follow the national development plan. Now, what happened in this case was that there was a 1,631 unit limit, I think, per acre or per square mile And that had been exceeded by County Meath in this development plan. So this body, Protect East Meath Limited, challenged that decision. The County Council was obviously supported by a number of developers who said, you've now brought in this plan and we've been making plans according to the limit that you've set down. And Mr. Justice Humphries said, well, that doesn't really matter, that the National Development Plan has to be followed. The legislation makes it clear that it has to be followed. And therefore, where the county development plan exceeds the limit set out in the National Development Plan, it is in breach and therefore has to be quashed.
Okay, really interesting. Okay, and finally to a defamation case which came before the Court of Appeal. The issue here was the statute of limitations, as the High Court had found that the plaintiff had not brought his case on time. This is the case of Reedy versus Pasek, another decision of Mr. Justice Houghton in the Court of Appeal. The court found that it did not have jurisdiction to extend time given, as there was a failure to issue proceedings within 2 years from the alleged defamatory publication.
Well, yeah, this goes back. Do you remember we talked a while ago to Martin Canny about the statute of limitations? And in defamation proceedings, there is a 1-year time limit, but the court does have the discretion to extend it for a further year. Now, what happened in this case was the plaintiff sought to bring defamation proceedings arising from an email that was sent to the court services. I don't think we need to go into the detail of the email, but what he originally brought proceedings that were in some way flawed and was struck out for want of jurisdiction. And the judge at that stage said that 1 year had already passed, so that if he wanted to bring his case, he had to bring it very quickly. But he didn't bring it quickly. He issued proceedings outside the 2-year limit. And so what happened was that the High Court said they simply didn't have jurisdiction to allow him to bring those proceedings, and that was upheld by Mr. Justice Houghton in the Court of Appeal.
He'd run out of time. Very simple.
Exactly.
Really, yeah. Okay, so back shortly with our interview with Mr. Justice Richard Humphries.
Silence in the Fifth Court.
So I'm delighted to be joined in the studio today by Mr. Justice Richard Humphries, who Mr. Justice Humphries has been on the High Court since 2015. Prior to that, he was a county councillor in the County Council of Dunleary Rathdown. He was an advisor to the government in the multi-party talks leading to the Good Friday Agreement. He's written 2 books in relation to the effects of the Good Friday Agreement, one called Beyond the Border, the Good Friday Agreement and Irish Unity After Brexit. And the most recent one is called Reconciling Ireland, which was published in 2021. However, he's here to join me today to discuss the issue of whether judges have used Wikipedia in their researches before writing judgments. A couple of weeks ago, we spoke to Dr. Brian Flanagan of Maynooth University, who had co-authored a paper with a number of his colleagues in Maynooth University and the Massachusetts Institute of Technology. And they claimed to be able to establish, using analysis of judgments and Wikipedia and statistical software, that there had been a marked Wikipedia effect on Irish judgments. And Mr. Justice Humphries and a number of co-authors have written a paper in reply to that. So, Mr. Justice Humphries, thank you very much for joining here in the studio.
Mark, thank you very much for having me. And can I congratulate yourself and Peter on your show and your podcast? They've been really excellent with many good interviewees, and certainly I've heard a lot of very positive comment from practitioners.
Thank you very much, Judge,
about your show.
Thank you.
And on a personal note, you mentioned a previous life I had under Article 28A of the Constitution. It's nice to be back here in Dublin South FM studios in Dundrum, where you're recording your show. I was here before on numerous previous occasions in a different role in another life that's long faded from memory at this stage.
Yeah, so we've put all that behind us,
exactly.
and concentrating on dispensing justice.
Exactly.
Yes, the paper that you wrote, along with a number of judicial assistants and former judicial assistants from the High Court, is entitled "Academia by Speculation: Debunking the Flawed Science Behind the Claim that Wikipedia Influences Judges." So I think it's fair to say that the title rather gives away the conclusion. Is that fair to say?
Yeah, it certainly signals the conclusion, and I suppose it was something of a response to the title of the original paper, which was Trial by Internet.
Yeah.
And I suppose one of the many problems, and you didn't really have to read beyond the first 3 words of the title to see the problem, is that their paper didn't establish or even provide any evidence of any kind for the idea that the trial of cases in Ireland or anywhere else is conducted, inverted commas, by internet. And in fact, you made that point when you had your guest on previously, that there is no evidence that any actual decisions are being affected.
Well, should we go back to the methodology in a minute? But I suppose what I'd like to start by asking you is, to what extent the paper required a response from the judiciary in the first place? Because obviously things are written about the courts and judges and their judgments quite often, which must hit a nerve quite often with various judges. And the general tendency is for the courts not to respond to what is written in the press. And yet, in relation to this paper, there's been a public response by yourself and Mr. Justice Barneville, who's the President of the High Court, and I think Mr. Justice Ferreter, who've all publicly queried the conclusions. What was it about this paper that you think required a response?
Well, first of all, I agree with you that a lot of criticism is best just ignored because it is very often just not terribly well informed. I mean, a good example is if somebody doesn't like the result of a case, they'll complain about the judge. But, the result is meant to be dictated by legal reasons. And you can't judge a judgment solely by whether you agree with the result or not. So a lot of criticism is best ignored, and certainly a lot of criticism of judges in their capacity as judges. In other words, their writing of judgments or carrying out of trials or whatever. But this was, I suppose, in a slightly more freedom of expression category where this was an academic paper, so it can be responded to academically. And that's what we tried to do. But why did we get involved? I mean, there were probably a number of reasons. For me, one important reason was because I think some people saw this as a reflection on judicial assistants who were a junior layer of legally qualified people who were employed by the court service to assist judges in their work. And, they're not a group that can really sort of defend themselves very effectively in the same way that other kind of powerful institutions can. So judicial assistants are a very important resource, and certainly I couldn't do the job without them. And there was a previous occasion where somebody came up with the theory that having judicial assistants was unconstitutional. So I wanted to defend judicial assistants on that occasion. So myself and some JAs then contributed an article to the Irish Law Times, knocking that one on the head. And I suppose this was a similar example where, insofar as it was suggested that people are looking up Wikipedia to write judgments, that was a reflection on them as well. So I wanted to, with a number of judicial assistant co-authors and other JAs who were helping in the background, put together a reply. So, I mean, that was one reason, certainly.
Was the international nature of the paper a concern? I mean, if you go to, a lot of judges, obviously, they go to international conferences. Would there be the sort of fear that people would go, oh, we hear in Ireland you're using Wikipedia to write your judgments?
Yeah, I mean, I think it's fair to say that the original authors do seem to have somehow stimulated a degree of attention to their paper. I mean, they put out a press release at a stage when it was just a preprint, not peer-reviewed. They've changed the paper since, and some of the phrases in the original paper are still there in media, uncritical media coverage of the first version. So yeah, that certainly didn't help. I mean, for me, it was kind of interesting just from a science point of view. This was a scientific paper, supposedly. Now, in fact, I mean, as soon as I looked at it, I could see that the conclusions were terrible science that wouldn't stand up. But it was, I suppose, something of a challenge then, just to work out, can we demonstrate that, and how do we demonstrate that, and how difficult is it to demonstrate that?
Maybe we could move on to that. I mean, you obviously went to some lengths to investigate or to debunk, however you want to put it, the original claims. Could you outline what you and your co-authors did to investigate whether there was any validity behind it?
Sure. Well, there were a couple of dimensions to it. The first thing we did was to count the citations ourselves. And one of the major flaws in their paper was that they had a fairly open-ended period up to about 20 years before the Wikification process of creating these Wikipedia articles. Then they had a sort of a fairly lengthy, maybe one and a half year period.
When you say a 20-year period, do you mean that the judgments that were put on Wikipedia covered a 20-year span?
No. What I mean is that they created Wikipedia articles about a cohort of Supreme Court cases, and then they had a separate cohort as a control group, which they created the articles, but they didn't publish them. Now, that's all fine, and I've no issue with that methodology, and makes sense, because the conceit was to measure any change in citation of articles where where the article was published, whether it was published, but it's not enough just to do that. You have to compare it against a group that hasn't been published as a control group. So, so far so good, and I would agree with that sort of methodology, but it went wrong for them after that because, so they were comparing citations before and after they put it on the internet. But now, even leaving aside the fact that it took quite a long time, maybe a year plus to year and a half to actually publish all these articles and populate them, they were comparing a 20-year period, up to 20 years, of citations before the Wikipedia page was published, with only about a 2-year period after the Wikipedia article was published. And anybody involved in practice will know that citation of cases follows trends. It goes up and down. It depends on the judge, the issues that are topical. Sometimes if judges are promoted, there's an increase in interest in their first instance decisions. If a topic comes to the Supreme Court, if there's legislative change, then it's just because it's a Supreme Court decision, it mightn't necessarily continue to be relevant. So my point is, there are fashions and trends, and what judges of 20 years ago decided really has no predictive value. So
were they not just comparing the citation or non-citation of the 154 judgments in the 2-year period after they had uploaded the Wikipedia articles?
They were comparing it before and after.
Okay.
So the 2-year period after was compared with an anything up to 20-year period before.
Right.
And the point I'm making to you is what judges did 10 years ago, retired judges now, has many of them are, has no predictive value whatsoever on what a judge would have done but for a Wikipedia article.
Yeah.
So in other words, if there are changes, it's nothing to do with the Wikipedia. Anyway, long story short, we just compared 2 years before the Wikipedia articles with 2 years after, and we found that there was no effect whatsoever. They both changed by exactly the same amount to 1 decimal place.
Right.
So there is no effect, is the conclusion that would be supported by our research once you correct for that fairly fatal flaw. The other thing we did then was look at where these citations are coming from. So which they didn't attempt at all. We took what we thought was a reasonably representative sample, which was the last High Court decision to refer to any of the Wikified cases. And we checked out the submissions, which are in principle available in the central office. And the vast majority of citations in judgments come from submissions. Surprise, surprise, hold the front page. Practitioners know that.
Yeah.
And then there would be a residual category then where the case is referred to in material that is in the submission. So the court looks at the submission, looks at the case, then goes on to look at the cases mentioned in that case. Or else cases where the judge has some prior knowledge as demonstrated by their previous writings or previous judgments. And there was only one exception, which was a really unusual case of a ex parte lay litigant application, which by definition, nobody's giving legal submissions. So the court has to do their own research.
Yeah. I mean, one of the criticisms in your paper that you make of theirs is that it wasn't peer reviewed. And I suppose if you read your paper, there's no doubt that because all of the authors are employees of the court services, there's a sort of, should we say, a vested interest in debunking the claim to a certain extent. Did you consider either sort of commissioning an independent review or finding people who would not necessarily have a vested interest in debunking the original claims?
Well, you see, the problem with the vested interest argument, we did refer to this in the paper and we said we didn't consider it disqualifying because anybody with practical knowledge of this area would be in the same position. They would, potentially be involved in judgments either by writing them, assisting to prepare them, or by making submissions. So we didn't consider that it was in any way a kind of a competing interest. We did write a summary paper and submit it to the Irish Law Times, which published it. The Irish Law Times is a peer-reviewed journal. And then we were invited by the editor of the Cambridge Handbook of Experimental Jurisprudence to submit the paper as a chapter to that.
So in fact, your paper will appear as another chapter in the same book that the original paper appears in?
That seems to be the intention, all right. Yeah. But as I say, we've already published the summary in the Irish Law Times.
And this in what with the SSRN, I think it's called, isn't it?
And the full paper is publicly available on SSRN. Yeah, but I mean, that takes us to another point about people's knowledge and expertise. I mean, every judge that I'm aware of that has commented since our paper came out, and every judicial assistant that has spoken to me or commented on social media, and every practicing barrister or solicitor has expressed some doubt about their paper and is either sort of circulated ours or endorsed ours or said something positive. I'm not aware of anybody, any serious person, who has read their paper in full, read our paper in full, and has said, no, these judges and judicial assistants have got the wrong end of it. And in fact, it doesn't end there, because you had an open mic here for one of the co-authors and for half an hour, and he didn't knock down any of our criticisms at all. In fact, he didn't really engage with them.
Well,
so people can draw their own conclusions about that, I think.
Yeah. I mean, I suppose I expressed myself reasonably forcefully in that interview in terms of the claims they made. So
no, you did, Mark. And I think in fairness, that might go down as one of the great cross-examinations of all time, because you had him on the canvas after the first question, really. And I don't think he really got up after that. I mean, the basic point was they didn't have any answers to these fairly devastating criticisms. And I'm happy to go through them individually if you want to hear them.
I suppose maybe if you briefly address, I suppose the first thing that you address, or one of the things that you address in your paper, is the issue of whether the citations come from the submissions rather than from the research done by the judges or the JAs themselves. And I think you've just told us that the majority of the citations obviously come from the submissions by the barristers. So if anybody's guilty of online research, it's more likely to be the counsel than the bench.
Yeah, the vast majority come from the submissions, a significant majority. But I don't think there's any reliable evidence that barristers were unduly relying on Wikipedia or Google or anything like that either. I mean, not that there's anything wrong with it. You see, this is the other sort of bizarre feature. I mean, one of the points we made in the paper is that people shouldn't be shamed for looking at Wikipedia or any online sources, as long as there's one major proviso, which is as long as they know its limitations.
Yeah, I mean, I think that's something I think we sort of need to go into. I mean, you know, I mean, my own view of Wikipedia is that, I mean, I think it's not unreasonable to describe it as the biggest voluntary project in the history of the earth. I mean, the sheer quantity of people who prepare articles and prepare what appear to be very reliable articles. And I think people find themselves in Wikipedia almost without thinking about it when they use the internet. So I suppose that goes back to the original question, why would it matter if the judges were using Wikipedia for their research? Because it is, you know, it is widely used, providing, as you say, that you realize that it's a link to an authoritative text rather than being an authoritative text itself.
Sure, you can't rely on it on its own for anything important. And indeed, the internal rules of Wikipedia say that because they require you to give sources for anything that's put up on Wikipedia. But, you know, I suppose to be entirely candid, I mean, one's sort of put in a difficult position by these kind of fairly bizarre sort of accusations, because on the one hand, I'm saying, well, we took this seriously as a scientific study. We looked at it and it fell to pieces. You know, it has been completely discredited on a number of grounds. I mentioned some of them, but there are plenty of others if you want to get into them. But the other thing is, even if it was valid, legal practitioners can look at dictionaries, they can look at textbooks, they can look at online sources. Wikipedia is just another one. And while the original paper made the kind of what we call the schoolboy debating point that, anybody can edit it, Professor Steven Pinker made the point recently in one of his books that isn't the interesting thing about Wikipedia. What's interesting is that it is astonishingly accurate, which is counterintuitive. But nonetheless, there have been, you know, studies carried out to show that it is quite accurate in many respects.
Well, I suppose the other thing they say in their original paper is that they suggest that judges are substituting their own legal reasoning to that of Wikipedia, when there's no reason to suggest that a judgment that they were linked to by Wikipedia was in any way colouring the outcome of the decision.
Well, no, you put that point to the author you had on here, and I didn't think his response was terribly persuasive. I mean, and I suppose that kind of amateur moralising was one of the reasons that you used the phrase irritating about their paper. And I suppose I'm struggling to think of a better word. But there was this sort of energy kind of about their paper, kind of schoolyard jeering, ha ha, you say you're experts, you're cogging your homework from Wikipedia, scarlet for your ma kind of thing. That was the energy. And, you know, that sort of, I mean, I think they were digging their own grave with that sort of approach. It sort of invited a reply, and a fairly robust reply. The point is, you know, that kind of amateur moralising, I mean, I can read out exactly what they said, but, you know, trial by internet kind of tells you all that you need to know, really. They didn't prove that, or they didn't even evidence it. That kind of amateur moralising, you know, that sort of Wikipedia shaming, to my mind, it's inappropriate, even if their study was scientifically valid, which it isn't.
Right. Well, I suppose as both papers are up online, we can leave it to listeners to find both of them and draw their own conclusions. I suppose, I mean, going back to the issue of whether Wikipedia can be used, I mean, the great debate now is to do with things like the use of ChatGPT. And I mean, it does seem to me that we're likely to come to a stage very soon when somebody can effectively talk to a large language model as I think they're called, and effectively give the facts of a case, and it will produce what looks like quite a reasoned judgment. And I suppose I find myself wondering, are the Irish judiciary or the judiciary anywhere looking at these sort of issues in terms of how the courts will be working in the future? I mean, because certainly, from my own point of view, I've experimented with asking ChatGPT to, for example, write a statement of claim, and it produces something that is certainly, on the face of it, as good as anything you'll find in Bullen and Leak. So, it seems to me that these are things that all lawyers are going to be using in the future, and I imagine the judiciary won't be immune from that kind of influence.
Well, the short answer to it, is it being discussed? Not really as of now. We've got a lot on our plate. It's certainly been discussed in academia. I know the Institute of Advanced Legal Studies, which in the University of London, which I'm associated with, is looking at this among other things. But sure, to be a brave person who would try and predict how all of these kinds of technologies will sort of evolve into the future. I know it probably sounds terribly old-fashioned, but I do think there's a tremendous sort of degree of art to the whole business of advocacy, and therefore by definition to judging. It's not a mechanical process. You really see that when you get really, really excellent lawyers doing the advocacy, and you really see how the sort of level of sort of concentration, intelligence and depth that they've applied to the whole thing, how they select the cases to emphasize, how they know the court, the particular court they're going to be before, how they tailor the argument to that particular person's, now I won't say strong views, but I'll say to that person's judicial philosophy, shall we say, and to the way that they see things. So there is that huge human element of kind of human understanding and relationships, and a computer program, just can't ever substitute for that, because, by definition, we're talking about something with no kind of feeling or emotions.
Yeah, I suppose the way I would look at it, like I say, in terms of your first draft, if you're able to effectively ask a computer a question and get a first draft out of it that is, on the face of it, good, then your job becomes an editing one rather than a writing from first principles. And it does seem to me that it's not unlikely at all that is going to become a feature of legal writing or preparing pleadings.
I can see that. Authorship of a first draft in any context is important. It's not necessarily something to be delegated, because it can set the tone. I think one thing where computerization, and I'm a major fan in many respects, for instance, through being involved in rolling out the ShareFile platform for submission of pleadings and papers in the current list I'm involved in, and previously in the bankruptcy list. So there's no hard copies now. It's all uploading to an electronic platform. That's been a huge help. But one thing computers have done is make documents somewhat longer than they otherwise would be. Yeah. And I suppose I'd be slightly afraid of that. Creeping complexity is a huge problem.
That feature is very evident over the last 30 years in the Irish courts. It was reasonably common to see in the 1990s that, judgments would be 5 or 10 pages long. Now it's not uncommon to find 150, 200-page judgments. And I suspect that it's a cross between the use of the dictaphone, being able to cut and paste portions from other judgments, from legislation, and from perhaps even from submissions.
That is a problem, but it's a problem that can only get worse, because
that's my fear.
The pile of judgments isn't really subtracted from, except every once in a while when something's reversed or not followed, but that doesn't happen as often as you'd think. There are far more judgments added to the pile, and the number keeps growing, and they get longer. So, I've produced some terribly long ones myself, so I'm no exemplar in this business, but I do try and keep them short if it's at all possible, but it's quite difficult.
Well, I wouldn't dare personalize the issue, but as a general trend, I think I can say from my own experience that in 2011, there were about 650 judgments delivered every year, and now there's about 1,400 delivered every year. And if we continue on that trajectory, then it's going to be increasingly difficult for practitioners to keep on top of legal developments.
Sure. Well, you'd know all about that in your role with the excellent website, Decisis.ie.
I just plug it myself.
Which you edit. Yes, well, you're too modest, of course, but it is an excellent website. But, as are all of the other commercial websites, indeed, and VLEX was the one that they used in this study. But, practitioners, whether solicitors or barristers actively involved in advocacy, will just understand this point, that going back to this paper on Wikipedia, the authors just apparent complete lack of practical understanding of the mechanics of judgment reduction just is not the asset that they think it is. I mean, the notion of sort of 5 academics in an ivory tower, 2 of whom are in America.
Again, let's not over-personalise
I don't mean to over-personalise it at all, far from it. But the point is the best academic writing, the most practical one, is done by academics who are also all practitioners, part-time academics, who have written very, very practical textbooks, which, I've referred to a number of them. Hughes and Hughes, for example, or David Brown's Simons on Planning Law, just to take 2 very good examples, have been very useful in writing judgments. But, my point is, I suppose it's the exercise of academics kind of lecturing about the practical mechanics of judgment writing when they, have no actual knowledge of it. It's a bit like kind of, 5 monks in a monastery writing a practical guide to sex, parenting and relationships for the modern couple or something. I mean, it just has no credibility.
Right. I think on that note, given that we ended the interview with Dr. Flanagan on should we say a similar note, I'll let the many, many listeners to the Fifth Court decide where they stand on this particular issue. And I would urge them to read both the original paper and the response written by yourself and the judicial assistants and former judicial assistants. And on that note, we'll also obviously have the final question that I need to put to you, which is the question we ask all our guests. Do you have any book or film or other work of art that you would like to recommend to our listeners?
Can I be very boring and not recommend a work of art and just suggest a book for practitioners?
Whichever you like, yes.
Which is Antonin Scalia and Brian Garner's Making Your Case, which is a very modern and in-print book about advocacy. And they've got some really, really practical points, again, about keeping it short and sweet, keeping it to the point. And
notwithstanding the judicial philosophy, certainly of Scalia, would you be a fan of his own jurisprudence?
Well, I think originalism has been fairly well discredited at this stage. And it's a terrible, terrible philosophy in many respects. Richard Posner has demolished it on numerous occasions.
But it may be demolished, but I think it's still espoused by the US Supreme Court.
Well, strangely, some of them anyway. But so no would be the short answer as far as originalism is concerned. But I'm a huge fan of Scalia's writing. Right. He writes beautifully. And I think that's something, we can all aspire to. And, a lot of practitioners write beautifully in their submissions. And, it's a real pleasure when you get a submission like that. When you see somebody just has a gift for writing and an instinctive understanding of judicial philosophy, judicial psychology, rather. I mean, it's hard for people who don't. But for those who do, it really is something that has an impact and really makes you stop and think.
See. So thank you very much, Mr. Justice Humphries, for joining us here in the Fifth Court.
Thank you for having me.
The Fifth Court will adjourn until next week.
And that's all from this edition of The Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, Mr. Justice Richard Humphries, for coming into us today and giving the judge's position on the Maynooth University research. Mark, it's something I could see when you were talking to him that he feels very strongly about.
Certainly has very strong views, and I think he put them very well.
We've given both sides an outing now. Is that the end of it? Can we squeeze anything more out of this?
Well, I must say, I do find Wikipedia a very interesting subject. I think there's a lot to be discussed, and in fact there's another interview I hope we have in the pipeline concerning Wikipedia, but which does not concern this particular issue.
Sounds great. Looking forward to that. Okay, I would also like to say a big thank you to our producer Conal O'Moroyne and to the Dublin South Podcast Studios for their wonderful work in recording this show. Big shout out to David. Thank you. Great job, David, as always. And if you have any comments for us or any topics that you would like us to discuss, please get in touch on our website. We've recently had a number of great suggestions which we are pursuing and we're looking into, and we're always open to new ideas, and we would love people to come in with ideas, Mark. Isn't that it?
Yeah, and I mean, can I just say from a personal point of view, I mean, I always welcome feedback, and it's very interesting to know whether people value the cases at the beginning or the interview, if they'd like to hear more cases, fewer cases, that kind of thing, because we are always looking to improve the show. Yeah, no, great. And we have loyal listeners out there. So people who have kind of stayed with us right from the start. We're now on to episode 28, I think this one is. Yeah, please let us know, because the show can evolve as well if people feel that it should go in a different direction, and we're agreeable to that. Maybe, you never know. Okay, so from me, Peter Leonard. Myself, Mark Tottenham. Thanks for listening, and we'll see you soon in the Fifth Court.